Now, there's a victory for parents who had their children through artificial insemination. This as the High Court finds that both partners in a relationship that conceived a child this way should have parental rights. The High Court ruling scrapped parts of the Children's Act because it did not automatically recognize both parents in the partnership as the legal parents if they were not married. Let's discuss this further now with Karabo Ozah, Director at the Center for Child Law. Thank you very much for your time here on All Angles. Now, I was actually quite confused when I saw this because all along I thought that the Children's Act actually does cover parents who have conceived via artificial insemination.
Thank you so much for having me. So the Children's Act does cover parents who are married, who have conceived via artificial insemination. The challenge is then for parents who are unmarried, just like the applicants in this case, who plan to start a family and have now subsequently started a family. So they realize that once the child is born, they both will not be recognized as co-holders of parental responsibilities and rights and as parents of their child.
And this, of course, is a victory for the child, not only for the parents. I think what's important is that it means the child is also protected.
Very, very important, and that's the reason why us as a Center for Child Law intervened in the case, where two people have a child and both have an intention of bringing the child up together, whether only one of them donates his or her gametes. And it's very important to point out that this section did not only apply to unmarried same-sex couples, but also if you are unmarried heterosexual couples and you have a child through artificial insemination, you wouldn't have both of them be recognized as parents. So it's important for children to have both their parents recognized for purposes of obviously being brought up by two people together, for purposes of also inheritance, things that the judge even mentioned in the papers. In the judgment. So where you have both parents recognized, there are parental responsibilities and rights that flow from that are protective for the child, and that's why it's very important.
So, Karabo, just explain to me, because I didn't understand why, just because you're unmarried, you wouldn't both be seen as this child's parents, but when you are married, you would be. I just don't understand where that logic came from. Can you just take me back a little bit and help me understand that part?
Yeah, so it starts with the fact that there's a fiction created by the law that if I, for instance, as a Karabo, have my husband and unfortunately he's not able to have a viable sperm and we end up having a child through a sperm that's donated by another person, he's considered the father of the child. So that is what the law recognizes. But the same has not been captured as being applicable to people who are unmarried, because most of our law is kind of, archaic, still considers that marriage is the setup where children should be conceived. Obviously, at least it recognizes people who have gone through the civil union. Those are same-sex couples who are married. But there was still a problem in that if we are not married and I only used, I carried the baby, but the sperm was not from my husband, because of that lack of biological connection, he would not be recognized as the father of the child. Equally, then for the same-sex lesbian couple, for instance, one person would have egg. If they then get a sperm donor and the one other person carries the baby, only the one who carried the baby will be recognized, not the one who actually even gave her egg. So the way the law is drafted is very confusing and lacking in many respects. This is a first step to trying to sort it out, but there's quite a number of issues that are wrong with Section 40 that have been coming over the years that actually require that this goes back to Parliament for proper drafting of provisions recognizing the lived realities of people in our country.
Well, thank you very much. I was a bit confused about why it would be like that, but thank you, especially because the parent who donated either the egg or the sperm is doing it to help people have children, not necessarily doing it to themselves be the parent of that child that's conceived from the donation.
No, maybe let me just clarify. So if you have a lesbian couple, right, the two mothers, potential two mothers, they need sperm for them to procreate. But what you find is sometimes the one mother will say, okay, you take my egg, you take the sperm, and then you do the clinic, they do then the fertilization and then implant it in the other mother. So one person's egg is used, the other one carries the baby. the donor has no rights, and that's very important. The donor has no rights. It's not supposed to have any rights in terms of our law. That's very clear in Section 40. But then now I've given my egg, but my partner carried the baby that we had fertilized through sperm donation as well. Then I'm not recognized because she's the one who gave birth. So those are the anomalies that are there because of the fact that we're not married. But if we were married, we would both be recognized as parents. There are still other problems that even where people are married and have given birth, particularly lesbian couples, they then face hurdles at Home Affairs when they need to be registered as parents of the children. So there's quite a lot of systemic barriers that still exist that needs to be ironed out, starting with the Children's Act, going to the Birth and Registration Act. There's also the National Health Act that regulates the process of artificial insemination, and there are provisions there also that need to be reconsidered. But for now, we're just dealing with sorting out at least Section 40 of the Children's Act to make sure that both parents are recognized as holders of parental responsibilities and rights automatically, and that is to the benefit of the child.
All right. Well, I guess victory is well on its way. And of course, the law is quite complex, so we'll keep having to actually amend it and upgrade it. That was Karabo Ozah, Director at the Center for Child Law. Thank you very much for helping me understand that.